Welcome back to Florida Criminal Law TV on our Casual Friday short series answering viewer and user questions. I have another one for you, and I have to tell you, I really appreciate all of you who have written in and talked to me about the show, asked me questions about criminal law. It's been a lot of fun. It's probably the favorite thing I do is educating people about criminal law, because most, not all, of the people that we represent have no experience with the criminal justice system. And even when people have a prior record and they've been to court for it, they don't understand it from the perspective of a criminal defense lawyer, which can often lead to people stepping on one of those major bombs that we call the landmines through the minefield that is Florida criminal law. So let's roll on over to our next question, where a viewer asks, what will happen if I fail my drug test while on pretrial release? Now, this is something that I've been asked multiple times in my office, on the phone, clients sending email questions. What will happen if I fail my drug test on pretrial release? And my response has been consistent for a long time. What do you think? I'll give you 3 guesses and the first 2 don't count. And you already know the answer. If you fail a drug test on pretrial release, the bond will be revoked and you will go to jail until your case is resolved. So my advice is very simple. If you are out of jail and you are on bond, don't do anything that will violate your bond conditions, because bonds contain basically 2 components. Component number 1 is going to be the dollar amount for each count. And once that's determined and someone gets a bond and they make a bond, there's also often special conditions of bond. In a domestic, it's going to be no violent contact. In a DUI case, it may be no alcohol or drugs. And in most cases, there's a requirement, no illegal drugs, as part of the bond conditions. If it's a sex case, there may be a requirement to wear a GPS monitor if it's traveling to meet a minor. If it is a child pornography case, or if child pornography is attached as a count to a traveling case, then quite often there is a special bond condition of no usage of the internet. Now, we usually file motions in that scenario, pointing out the obvious that, hey, it's the 21st century, people need access to the internet, whether it's to look for a job, to communicate with family, whatever. Can't we put a net nanny on it? So with each of the special conditions of pretrial release, if there's one you have a problem with, let's say, for example, that you're prescribed medical marijuana for PTSD, one of the constitutional amendments, examples, and allowabilities for the use of marijuana. Well, you don't want to be set up to where you pop positive for THC. Your pretrial release supervisor does not know that you have a valid prescription in Florida because there's a lack of communication, and you're just thinking, hey, everything's fine, I have a script, and the next thing you know, there's a knock at the door, or you're visited at work in front of God and country, and you're buckled up and taken to jail for violating pretrial release. So the short answer is, it'll result in a bond revocation, but there may be some ways around it if your lawyer and legal team file the right pleadings, and that has to be handled on a case-by-case basis.